So, if you do this incredible improvised street dance
Right.
right in the middle of Paris, you legally own that choreography the absolute second you finish your last move.
It's yours instantly.
Yeah. But if you do that exact same dance in New York, well, you own absolutely nothing unless someone happened to be recording it on their phone.
Which is pretty wild when you think about it.
It is.
No.
And welcome to the deep dive. You handed us a massive, comprehensive source document today, a detailed Wikipedia article all about copyright.
Yeah, we're really getting into the weeds on this one.
We are. You gave us this because you wanted a shortcut to understanding this, like, invisible legal framework that dictates exactly how human creativity is owned, shared, and monetized.
Exactly.
We're talking about a system that affects literally everything in your daily life. You know, from the books you read in your commute to the memes you share in group chats.
It's everywhere.
It really is. I kind of think of copyright as the invisible real estate market of the human mind. Like, you can't see the property lines, but they are absolutely there.
Oh, for sure.
And they completely determine who gets to build a house, who has to pay rent, and who gets evicted for trespassing.
I love that analogy. And to carry that real estate analogy further, intellectual property isn't about owning the abstract concept of dirt.
Right.
It's about owning a specific surveyed plot of land. And the fundamental definition provided in our source material makes this very clear.
Which is?
Copyright does not protect ideas. It protects the original expression of an idea in a tangible form.
Okay, so meaning what exactly?
Well, meaning you cannot own the idea of a talking anthropomorphic mouse.
Oh, okay, I see where you're going with this.
Right. If we allowed people to own broad ideas, culture would just stagnate immediately. One person would own the concept of a love story or a mystery.
That would be a nightmare.
A total legal nightmare. But if you draw a specific talking mouse with red shorts and yellow shoes, well, you own that exact expression. The law protects the unique execution, not the underlying premise.
So the idea is free, but the execution is fenced off. But to really understand why those fences exist for you today, we kind of have to look backward. Because you can't understand the rules of the game today without knowing why the game was invented in the first place.
Right.
And for copyright, the inciting incident wasn't a law. It was actually a machine.
The printing press.
Yep. The printing press in the 15th and 16th centuries.
Yeah, because before the printing press, copying a book meant a scribe literally sitting in a room for months writing it out by hand.
Which is insane to think about now.
Right. There was no need for a massive legal framework because the physical friction of reproducing works made it inherently slow and super expensive.
It just regulated itself.
Exactly. But the printing press removed all that physical friction. It made reproducing works incredibly cheap and fast.
And initially, anyone who could afford to rent a press could print any text they wanted. So the earliest government interventions, they actually weren't designed to protect the authors who wrote the books at all.
No, not at all. The laws were designed purely for government control.
Right, like the English Parliament passing the Licensing of the Press Act in 1662. The mechanism here was just straight-up censorship.
Yeah, they wanted to keep a tight lid on things.
The law required all publications to be registered with a government-approved company, the Stationers' Company. If you didn't register your printing press and your text with them, your operation was illegal.
It was basically a way for the Crown to track and suppress scandalous or seditious pamphlets before they could spread.
But then the shift toward modern copyright happened a few decades later, right?
Yeah, with the Statute of Anne in 1710, enacted in England and Scotland, this legislation completely shifted the foundational premise.
How so?
Well, instead of vesting control in a printer's guild to censor material, it vested the rights to the authors themselves, or, their chosen publishers, for a fixed period of 14 years.
Okay.
The text of the act explicitly stated it was created, quote, for the encouragement of learning. So the mechanism of encouragement was a temporary economic monopoly.
Meaning, if creators know they will be the only ones legally allowed to sell their work for a decade or two, they have a real financial incentive to actually spend their time writing new books.
Exactly. Instead of, working in a field or something.
Okay, let's unpack this. Because our source material details an incredible historical divergence that happened about a century later, testing this exact theory.
Oh, the Germany and Italy comparison? This is fascinating.
It's so wild. So in the 19th century, the German states were really fragmented and basically lacked any strict unified copyright enforcement. It was essentially a legal free-for-all on educational and technical material?
Anyone could just copy a textbook.
Anyone. And the result of having no copyright, it led to this massive proliferation of cheap, mass-produced academic papers and handbooks.
Right.
And historians in our source suggest this flood of cheap information directly contributed to Germany's massive industrial and economic boom during that century. They effectively crowdsourced an industrial revolution by making knowledge dirt cheap.
Which is incredible. But then, at the exact same time, you look at Napoleonic Italy.
Right.
The source points to empirical evidence regarding Italian opera composers. Before Napoleon, the Italian states were also fragmented with weak protections.
So what happened there?
Well, composers just churned out low-quality work just to survive. But when the French arrived and introduced basic authors' rights, actually enforcing copyright across the region, the area saw a massive increase in both the number and the quality of operas.
Oh, wow.
Yeah, composers like Verdi could demand high fees for their exclusive rights, which meant they could take their time to write highly durable, popular masterpieces instead of just rushing out junk.
Wait, so Germany thrived by essentially having a free-for-all on educational material, while Italy got better operas by strictly protecting them.
That's what the data shows, yeah.
Does copyright actually promote progress then, or does it just make information more expensive?
Well, that tension defines the two major legal traditions we live with today. In the United States, you have the Constitution's Progress Clause. The underlying philosophy there is strictly utilitarian. Society strikes a bargain. We give you, the creator, a temporary economic monopoly, but only to incentivize you to produce things that will eventually benefit society as a whole.
Right. It's a trade-off.
Exactly. Now, contrast that with the European civil law concept of droit d'auteur, or author's rights.
The French tradition.
Right.
Yeah.
In this tradition, which solidified around the French Revolution, copyright is an absolute moral property right. The creative work is viewed as a literal extension of the author's personality and soul.
Wow, soul. That's heavy.
It is. The law isn't making a pragmatic business trade-off here. It is recognizing a fundamental human right of the creator.
But, I mean, this European idea of moral rights creates a massive logistical headache, doesn't it?
Oh, absolutely.
If an author's rights are tied to their soul in France, but seen as a temporary business contract in the United States, what happens when a Parisian publisher sells a book in New York? The laws just clash.
They do. And that's why the world needed a standardized baseline, which birthed the 1886 Berne Convention.
Okay, let's talk about Berne.
The Berne Convention is this watershed treaty that harmonized these property lines globally. It established the rule that copyright is automatic upon creation.
Automatic.
Yes.
Right.
You do not need to register your work, apply for a certificate, or pay a fee in countries adhering to the convention. The moment the expression is realized, the international legal protections apply.
Though it's definitely worth noting for you listening, the U.S. stubbornly held out from joining the Berne Convention until 1989.
They really did. They loved their formal requirement.
They loved having to legally include the little C inside a circle symbol and the year of publication on everything. But under Berne, the magic word for when a copyright is officially born is fixation.
Right, fixation. Fixing a work means putting it into a permanent state. But international law diverges on how strict this needs to be.
How so?
Well, in the U.S. and Canada, a work must be fixed in a tangible medium to receive protection. It has to be written on paper, saved to a hard drive, or, recorded on tape. It must be stable enough to be perceived or reproduced later. But the Berne Convention actually allows member countries to decide if tangible fixation is necessary. France and Spain explicitly do not require fixation.
Which brings us back to our Paris versus New York street dance scenario at the top of the deep dive.
Exactly.
In France, the act of expressing the choreography in the air is enough to instantly generate a copyright. But in the U.S., without a tangible recording, that dance legally vanishes the second it ends.
Poof, gone.
And speaking of tangible proof, this source material busts a massive myth that you have almost certainly heard of, the poor man's copyright.
Oh, I hear this one all the time.
Right. This is the idea that if you write a brilliant screenplay, you could just print a copy, seal it in an envelope, and mail it to yourself. The Postal Service stamps a date on it, you leave it sealed, and boom, you have ironclad proof of when you created it to use in court.
Yeah, unfortunately, that is complete fiction.
It is.
The United States Copyright Office explicitly states this practice is not a substitute for actual registration. Mailing an envelope to yourself does not legally prove anything in a definitive way.
Because it's too easy to fake.
Exactly. A defendant's lawyer could easily argue you mailed an unsealed envelope, left it open for years, and just slipped the script in yesterday.
Wow, okay.
Oh.
But if we connect this to the bigger picture, why bother filling out the official government paperwork at all if the Berne Convention says copyright is totally automatic the second you save the file?
Well, while the legal right exists automatically, enforcing that right in a courtroom requires leverage.
Leverage.
Right. In the United States, registering your copyright with the government serves as prima facie evidence. That legal term means the court automatically accepts your ownership as a baseline fact.
So it flips the script on the defense.
Exactly. The burden of proof shifts entirely onto the person who stole your work to prove you don't own it. And furthermore, formal registration is the key that unlocks statutory damages and attorney's fees.
Oh, that's huge.
It's everything. If someone pirates your unregistered photograph, you can only sue them for the actual literal profits you lost, which is notoriously difficult and expensive to prove.
Yeah. How do you even calculate that?
You basically can't.
Yeah.
But if you are registered, the law allows the judge to just hand you a massive set penalty fee without you having to prove exactly how many dollars you lost.
Okay, so we've established how a copyright is born, either through fixing it in a medium or just the act of creating it, and why you should probably register it. Let's draw the actual property line.
Let's do it.
What exactly do you own and what are the limits? Our source breaks this down into two categories: economic rights and moral rights.
Right.
Economic rights are all about the money. It's the exclusive right to reproduce the work, distribute copies, perform it publicly, or create derivative works, like taking your published novel and turning it into a screenplay.
Exactly, the stuff you can sell.
But then moral rights, that must be the reputation part we touched on with the European tradition. So if economic rights are about money, moral rights are about the soul of the work.
Spot on.
That's why I can't just buy a famous painting, legally own the canvas, and then draw a cartoon mustache on it, right?
Yeah. You are describing the right of integrity. Moral rights protect the creator's personal connection to the work, independent of who owns the economic rights.
Okay.
This includes the right of attribution, so demanding your name remains on your creation, and the right to legally object to the distortion or mutilation of your work if it would harm your honor or reputation.
And in some places, those last forever, right?
Yes. In jurisdictions like France, these moral rights last indefinitely. They belong to your heirs forever, even if you sold the economic rights to a publisher decades ago.
That is wild. But, society needs to interact with culture without getting sued every 5 seconds. There have to be limits.
Of course.
Because when you go to a bookstore and buy a physical paperback, you are absolutely allowed to turn around and resell it on eBay or give it to a friend. You just can't photocopy all the pages, bind them, and sell the copies.
Right.
So what does this all mean for me? It's like, I own the paper, but I'm only leasing the words.
That is a perfect way to put it. That mechanism is called the first sale doctrine.
The first sale doctrine.
Right. Once the copyright holder has authorized the first sale of a specific physical copy, their right to control the downstream distribution of that specific physical item is completely exhausted.
Okay, that makes sense.
The source highlights a landmark 2013 Supreme Court case to illustrate this. Kurtzang v. John Wiley & Sons.
Oh, this is the textbook case, right?
Yes. Kurtzang was a student from Thailand studying at Cornell University, and he realized that the exact same academic textbooks sold in the U.S. for hundreds of dollars were legally printed and sold in Asia by the publisher for a fraction of the price.
So he had his family buy the cheap editions in Thailand, ship them to the U.S., and he resold them to American students on eBay for a profit.
Smart guy.
Very smart. But the publisher, John Wiley & Sons, they sued him, claiming he was violating their exclusive right to distribute their copyrighted material in the United States.
But the Supreme Court ruled 6-3 in favor of the student.
Wow.
Yeah. They ruled that the first sale doctrine applies to copies lawfully made anywhere in the world. The publisher made their money on the first sale in Thailand. They don't get to control the secondary market in New York.
That is fascinating.
And beyond physical resales, society has a mechanism for using the actual expression itself without permission. Fair use in the United States or fair dealing in Commonwealth countries.
Okay, fair use.
Yeah, but fair use is not a hard and fast rule. It is a flexible balancing test applied by courts.
Right. The U.S. law uses 4 specific factors to weigh whether you can legally copy something for commentary, parody, or education.
Do you want to run through them?
Yeah, let's do it.
Yeah.
First is the purpose and character of the use. Like, are you making money off it, Or is it for a nonprofit educational use? Are you transforming the original meaning?
Crucial questions. What's the second?
Second is the nature of the original work. You have more leeway to quote from a factual biography than from a highly creative fantasy novel.
Makes sense. Facts on expression.
Right. Third is the amount and substantiality taken. Are you quoting one sentence of a movie in a 10-minute YouTube review, or are you just uploading the entire third act?
Yeah, courts don't like it when you take the whole thing.
Exactly. And fourth, perhaps the most critical, is the effect on the market.
Yeah.
Does your use replace the original? If your review acts as a substitute for watching the movie, well, you fail the test.
Yep. That's usually the nail in the coffin. But, there are also strict exemptions outside of fair use. The source brings up a really vital one regarding useful articles.
Oh, right.
This explains how giant fast fashion brands can legally copy the clothing designs of smaller boutique companies without facing massive lawsuits.
This blew my mind when I read it.
Right. In jurisdictions like Canada, items deemed useful articles like clothing or furniture are exempted from copyright protection if they reproduce more than 50 times.
So the underlying legal philosophy is that you cannot use copyright law to monopolize something the public fundamentally needs to use to survive, like a jacket or a chair.
Exactly. You can own the unique two-dimensional floral pattern printed onto the fabric of a shirt, but you cannot copyright the structural three-dimensional cut of the shirt itself.
That is such a fine line to walk. But, these delicate historical balances, the first sale doctrine, fair use balancing test, the useful articles exemption, they were meticulously calibrated over centuries.
They really were.
And they worked brilliantly for physical books, CDs, and jackets, because physical copying always degraded the quality, and physical distribution took real effort. But the digital age fundamentally broke this equilibrium.
It shattered it. A digital file can be copied infinitely with absolute zero loss of fidelity and distributed to millions globally in seconds.
The internet just blew the doors right off the hinges, and the producer's immediate response was to build digital walls.
Naturally.
The source details the rise of DRM, or digital rights management. This involves literal encryption to restrict access and digital watermarks to trace copies.
Yeah, but here is why DRM fundamentally changed the game. It shifted the enforcement of copyright from the legal system to computer code.
Oh, that's a huge shift.
It is. If you buy a DVD with DRM encryption, the code physically prevents you from copying a clip. It does not matter if you have a perfectly legal fair use right to use that clip for a college presentation.
Right, because the code doesn't care.
Exactly. The code does not understand the 4 factors of fair use. It just says no.
And the driving fear behind building those DRM walls is, of course, digital piracy. The economic data on this is staggering, though the actual impact is highly debated.
Very heavily debated.
Our source cites a 2019 study sponsored by the U.S. Chamber of Commerce. Their methodology concluded that global online piracy costs the United States economy at least $29.2 billion in lost revenue every single year.
But that's billion with a B.
Right. And you have massive IP commission reports citing hundreds of billions lost to counterfeit goods and pirated software worldwide.
It's a massive reported drain.
But here's where it gets really interesting. Because the source material presents a stark, almost unbelievable contradiction. Alongside those industry reports claiming tens of billions in losses, it cites a 2014 university study looking at the music industry.
Oh, the YouTube study.
Yeah, that academic study concluded that free, pirated music content accessed on platforms like YouTube doesn't necessarily hurt sales at all. In fact, they found it has the potential to actually increase legitimate sales by acting as a massive, frictionless discovery tool for new artists.
That is quite the contrast.
It is. And just to be clear to you listening, we aren't endorsing either of these viewpoints or taking a side. We're simply conveying the contradictory data our sources have provided. But it really shows how deeply the digital age has disrupted the core utilitarian theory of copyright.
It definitely forces us to ask a big question. Is piracy a purely economic black hole that destroys the incentive to create? Or, in the digital era, has it accidentally become a bizarre, informal system of global marketing? If giving your work away for free actually increases your revenue through touring or merchandise, the old progress clause math of needing a strict monopoly gets very, very complicated.
It does. And this friction forced the system to adapt, leading to the creation of the Creative Commons.
Yeah.
Founded in 2001 by legal scholars like Lawrence Lessig, the Creative Commons acts as an alternative to the rigid default, all rights reserved status of traditional copyright.
And the mechanism of the Creative Commons is brilliant in its simplicity. It provides standardized, free legal licenses that allow creators to voluntarily waive certain rights up front.
So instead of forcing every single person to hire a lawyer to negotiate a use case?
Exactly. You just attach a Creative Commons license that tells the world, hey, you can use my song in your video right now as long as you credit me and don't monetize the video. By 2009, over 130 million individuals had utilized these licenses to share their work.
It's just a great way for creators to say they value sharing and remixing culture more than strict economic control. But, while the internet pushed for sharing, traditional corporate copyright actually lobbied to go the exact opposite direction.
Oh yeah, they wanted things locked down for longer.
Making copyrights last significantly longer. Originally, under the U.S. Copyright Act of 1790, your protection lasted 14 years, renewable for another 14. But today, in most of the world, it lasts for the life of the author plus an additional 50 or 70 years after they die.
Yeah, the source specifically highlights the 1998 Copyright Term Extension Act in the U.S., which controversially added another 20 years to the term.
Right.
This legislation faced massive public criticism. The core allegation was that the extension was heavily promoted by massive media corporations who were sitting on incredibly valuable copyrights like early cartoon characters that were just about to expire.
So they lobbied to change the law to keep their property fenced off for 2 more decades. But the clock eventually runs out on everyone. Which brings us to the ultimate fate of all creative works, the public domain.
The public domain.
Once that statutorily determined term finally expires, the invisible property lines vanish. The work belongs to everyone.
It's totally free.
You can use it, remix it, or sell it without asking for permission and without paying a dime. All the books published in the U.S. before 1929, for example, are now sitting in the public domain. It is the grand recycling bin of human culture.
And the public domain represents the final, ultimate fulfillment of that original bargain we struck back in the 18th century. The individual creator got their exclusive time to profit and build their legacy.
Right.
And in return, society eventually gets permanent, unrestricted access to the culture it helped foster, ensuring the building blocks of creativity are available for the next generation.
So, to summarize this incredible journey for you today, we started with scribes writing in the dark, moved through the censorship of the English Licensing Act, watched Germany and Italy accidentally beta test the economics of sharing, and finally arrived at modern YouTube takedowns and Creative Commons licenses.
It's been quite a ride.
The next time you buy a cheap fast fashion jacket, resell a college textbook on eBay, or click agree on a digital software update, realize that you are directly participating in a centuries-old tug-of-war over human expression.
It is a constant calibration, forever balancing the economic and moral rights of the individual creator against the cultural and educational needs of society at large.
And before we go, I want to look at the related topics listed at the very top of our source document, because there's one that poses an existential question for the future of everything we just discussed.
Oh, I know where you're going with this.
Throughout this entire deep dive, we've established that copyright relies entirely on human creative expression and originality. From the utilitarian courts in the U.S. to the soul-driven droit d'auteur in Europe, the law explicitly requires a human author.
Right, a human being.
But as we enter the era of artificial intelligence, what happens when an AI generates a masterpiece? Does the invisible property line belong to the programmer who built the model?
Good question.
Does it belong to the person who typed the prompt? Or does it belong to absolutely no one, immediately dropping into the public domain because there was no human soul behind the expression? As the invisible real estate market of the human mind expands into the realm of the machine, who gets to own the new property lines? Something for you to mull over. Thanks for joining us on this deep dive.